Hello lovely people, I am Radha Tripathi and I welcome you all to this second session of Chhattisgarh Judicial Services Analysis. In this session, we'll decode the statutes and unveil the winning strategies. Let me tell you a secret. Edzorb has got the winning formula that sets it apart. So you'll be witnessing how the correct mindset and the correct guidance translates it to the victory. So without any further delay, let's get started. Alright, so now we have question number 51. The juristic concept of the contract consists of offer and acceptance, consideration and coercion, agreement and obligation, free consent and capacity. The correct answer is C, agreement and obligation. And this was from the module 2 of Edzorb Law Premium 3.0. Now the next question, question number 52. Which of the following is an essential component of a valid contract? Equality in the bargaining power between the parties, social and economic pressures the parties are exposed to, dominance of one party over the others, competence and the contractual capacity of the parties. The correct answer is D. And this was from the simplified notes of section 10 Edzorb Law Premium. Let's see section 10. Section 10 says that all agreements are contract if they are made by the free consent of the parties competent to contract for a lawful consideration with the lawful object and are not expressly declared to be void. So in short, इसी section में हमें पता चल गया कि what are the essentials of the contract. See, it is beautifully presented here, the essentials of the contract. Free consent, competent to contract, lawful consideration, lawful object, and not to be void. Okay. Now further provisos are provided to you. Nothing shall affect any law in force in India. Secondly, not expressly repealed. Contract is required to be in writing or in presence of the witness. Any law relating to the registration of the document. So, ये सारे इसके exceptions हैं. Now, moving on to the question of 53. The communication of acceptance through telephone is regarded as complete when acceptance is spoken on phone, acceptance comes to the knowledge of the party proposing, or acceptance is put in the course of transmission. Acceptor has done whatever it is required to be done by him. The correct answer is B. Acceptance comes to the knowledge of the party proposing. And this was from the module 4 of Edzorb Law Q-Bank. See, section 4 में provided है communication of acceptance कैसे होता है. See, ये act हमारा पुराना है, ठीक है. तो ये जब ये सेक्शन बनाया गया था तो इसका मेन मोटिव था एक्सेप्टेंस कब कंप्लीट होगी ये जानना कि थ्रू लेटर्स जब प्रपोजल्स और एक्सेप्टेंस आते हैं तो कब कंप्लीट माने जाएंगे, ठीक है. तो ये सेक्शन तब का है, तो ये काफी कंफ्यूजिंग होता है. लेट मी एक्सप्लेन इट टू यू इन अ इजियर मेथड. सी, सबसे पहले प्रपोजल की बात करते हैं कि प्रपोजल्स कैसे कब एक्सेप्टेड माने जाते हैं. पहली चीज ये समझनी है हमको, इसको टू पार्टीज के रिस्पेक्टिव में समझना पड़ेगा. फर्स्ट द प्रपोजर एंड सेकंड वन इज द एक्सेप्टर. तो सी, दिस इज अ प्रपोजर और ये है एक्सेप्टर, ठीक है. दोनों के रेफरेंस में डिफरेंट टाइम होगा जब प्रपोजल की कम्युनिकेशन कंप्लीट मानी जाएगी. तो प्रपोजल के रिस्पेक्ट में समझते हैं. जैसे ही इन्होंने अपना प्रपोजल या फिर ऑफर सेंड किया और ये एक्सेप्टर की नॉलेज में आता है तो ये अगेंस्ट प्रपोजल कंप्लीट हो जाता है, ठीक है. और एक्सेप्टर के अगेंस्ट कब कंप्लीट होगा प्रपोजल? जब ये इसकी नॉलेज में आ जाएगा. जब ये एक्सेप्टर की नॉलेज में आ जाएगा तो प्रपोजल कंप्लीट हो जाएगा, ठीक है. अब दूसरी बात समझते हैं. ये तो इजी था. थोड़ा सा जो कॉम्प्लिकेटेड है दैट इज अबाउट द एक्सेप्टेंस के बारे में जानना कि उसकी कम्युनिकेशन कब कंप्लीट मानी जाती है. ये भी हमको एक्सेप्टर और प्रपोजल, एक्सेप्टर एंड प्रपोजर दोनों के रिस्पेक्ट में समझना पड़ेगा. देखते हैं, ये प्रपोजर और ये है एक्सेप्टर. ऑलराइट. तो प्रपोजल एक्सेप्टेंस की कम्युनिकेशन अगेंस्ट प्रपोजर कब कंप्लीट मानी जाएगी? जब अब ये प्रपोजल इसके पास पहुंच गया. अब सपोज ये है एक्सेप्टेंस, ठीक है, ये लेटर के थ्रू गई. अगेंस्ट द प्रपोजर the communication of acceptance is completed when it is put in the course of transmission. The moment acceptor has put it in a post office, suppose, ये प्रपोजर के अगेंस्ट कंप्लीट हो गई, ठीक है. सेकेंडली, अब एक्सेप्टर के अगेंस्ट कब कंप्लीट होगी? एक्सेप्टर के अगेंस्ट तब कंप्लीट होगी जब ये एक्सेप्टेंस इट कम्स इनटू द नॉलेज ऑफ प्रपोजर. तब ये एक्सेप्टर के अगेंस्ट भी कंप्लीट हो जाएगी. ऑलराइट, होप इट हेल्प्ड यू. ओके, नाउ मूविंग फर्दर टू द नेक्स्ट क्वेश्चन. क्वेश्चन नंबर 54. The denatured has been defined under dash of the Chhattisgarh Excise Act. The correct answer is section 2 clause 5 and this was from the मॉड्यूल 1 ऑफ द MCQ फैक्ट्री 3.0। अब सी ये छत्तीसगढ़ एक्साइज एक्ट से आया हुआ है। आई एम रिपीटिंग इट अगेन। एडजॉर्ब के टेलीग्राम चैनल पे ये पूरा एक्ट आपको फ्री ऑफ कॉस्ट इन एडजॉर्ब वे प्रोवाइडेड है। पूरा लोकल लॉ आपको प्रोवाइडेड है। आपको बहुत हेल्प मिलेगी इन योर अपकमिंग एग्जाम्स। ऑलराइट, सो जॉइन दैट टेलीग्राम ग्रुप एंड गेट दिस फॉर योरसेल्फ। ओके, now we have question number 55. Passes for the import, export and transport of the intoxicants may be granted by the Excise Commissioner, Chief Revenue Authority, Collector, Officer appointed by the state government. The correct answer is C, the Collector. This is again from the Chhattisgarh Excise Act, Module 1, MCQ Factory. Okay, now the next question. This is again from the Excise Act. Provisions relating to the closing of shops for the sake of public peace is provided under Section 18, 21, 24, 23, subclause A. The correct answer is Section 24. All right, and this was from the module 4 of the Edzorb law premium. Moving further, who is competent authority for permitting establishment or licensing of the distilleries and warehouses? Collector, Excise Inspector, Excise Commissioner, State Government. The correct answer is C, Excise Commissioner. And this was from the module 3 of the MCQ Factory 3.0. Moving further, question number 58. Whose prior permission is essential for granting license to sell liquor in the cantonment area? The correct answer is commanding officer, and it was from the module 3 of the MCQ Factory 3.0. Now we have next question. Provision relating to form and condition of license is provided under where? Section 28, 28A, Section 29, Section 40. The correct answer is Section 28. Okay, this was from the module 4 of the Chhattisgarh Excise Act. आप देखिए Excise Act में से कितने questions आए हुए हैं. Go help yourselves, download that content and have an edge over others. All right. Edzorb also conducts the main test series. स्टेट के पैटर्न के हिसाब से, उसके एग्जाम्स के हिसाब से और जिस तरह का इवैल्यूएशन वहाँ होता है उस हिसाब से मेंस टेस्ट सीरीज कंडक्ट होती है और उसी तरह से इवैल्यूएशन होता है। आपको प्रॉपर फीडबैक मिलता है जिससे कि आपको पता चले कि आपके लूप होल्स कहाँ हैं और आपको उसको आगे एग्जाम में बेटर करने में इजी हो। ठीक है, तो पहले एक आंसर राइटिंग आपको मिल जाती है, आपको जजमेंट राइटिंग भी मिल जाती है, एसे राइटिंग मिलती है एंड फर्दर ट्रांसलेशन इज ऑल्सो प्रोवाइडेड टू यू। ऑलराइट, now we have next question. Immovable property has been defined under which section of the Registration Act? Section 2, subclause 5, subclause 6, subclause 10, subclause 9. The correct answer is subclause 6. And this was from the module 1 of the Edzorb Law Q Bank Registration Act. Okay, so this is provided under section 2, subclause 6, immovable property. See, आपको visual representations में यहाँ दिखाया गया है कि immovable property does not include standing timber, growing crops and grass. तो अब जब आपको पिक्चर से पता चल गया ना, नहीं लोगों को पता ही नहीं होता स्टैंडिंग टिम्बर है क्या, अब आपको पता चल गया, ये पिक्चर आपके दिमाग में छप गई और एग्जाम में आपको याद आएगी। ठीक है, what it includes ऊपर बता दिया, what it does not include and what it includes land and buildings, hereditary allowance, right to way, light fisheries, benefits arising out of land, things attached to earth and things passing to earth. Okay, and this is the case law related to that. In this case, it was discussed whether the trees are regarded as movable property or immovable property. तो immovable property कब होगी? जब intention is that trees should continue to have benefit of further sustenance. और movable property कब होगी? जब intention is to oust them down or later for the purpose of utilizing the wood further. तो ultimately everything depends upon the intention when it comes to the trees. अगर आपका मन ये है कि वो trees लगे रहें, you keep on having the fruits and from them, तो वो immovable property होगी. But if your intention is such that they need to be cut down and you will be using the woods of that, तो ये movable property में आएगा. All right, it's an important case law and it can come in your exam. हो सकता है इस बार एग्जाम में पूछ लें, अभी पूछ लिया सेक्शन, अब पूछ लेंगे केस लॉ, तो ऐसे हमको साथ में सब कुछ पढ़ना पड़ेगा. एंड फर्दर ये इमूवेबल प्रॉपर्टी की डेफिनेशन सिर्फ इस एक्ट में नहीं प्रोवाइडेड है, ये टीपीए में भी प्रोवाइडेड है सेक्शन 3. उसमें भी यही लिखा है कि इट डज नॉट इंक्लूड स्टैंडिंग टिम्बर, ग्रोइंग क्रॉप्स एंड ग्रास. ठीक है, फर्दर जनरल क्लॉजेज एक्ट में भी ये प्रोवाइडेड है सेक्शन 3 सब क्लॉज 26 में कि व्हाट इमूवेबल प्रॉपर्टी इंक्लूड्स. ऑलराइट, एंड फर्दर और उसके सेक्शंस आपको दिए हुए हैं. सेक्शन 27 में लीज के बारे में है, 28 इज अबाउट द माइनर, 29 इज अबाउट द मूवेबल प्रॉपर्टी. सी, यही ब्यूटी है एड्सॉर्ब की. अब आपने सिर्फ रजिस्ट्रेशन एक्ट नहीं देखा, आपने देखा ट्रांसफर ऑफ प्रॉपर्टी एक्ट, आपने देखा जनरल क्लॉजेस एक्ट. अब अगर आप नॉर्मल एमसीक्यू की बुक से सॉल्व करते तो क्या आप टीपीए उठा के देखते कि ये वहां पे भी प्रोवाइडेड है? आपको कैसे पता चलता? तो आपको जब सब चीजें एक साथ मिल जाती हैं तो चीजें बहुत ईजी हो जाती हैं. ऑलराइट, क्यों अपने आप को अननेसेसरी कॉम्प्लिकेट करना है? Now we have question number 62. Section 16A of the Registration Act was added in which year? 2001, 1999, 2004, 1998. The correct answer is A. It is in year 2001. Okay, and this was from the module 3 of the MCQ Factory 3.0. Moving further, provisions relating to inquiry before registration by registering officer is provided under which section? Section number 34, and this was from the module 2 of the Edzorb law Q bank. अब सी इस एग्जाम में आपने अभी भी देखा, पिछले सेक्शन में भी हमने देखा, देयर वर लॉट ऑफ क्वेश्चंस व्हिच वर आस्क्ड फ्रॉम द सेक्शन नंबर्स. तो हर पेपर का पैटर्न अलग होता है, उसकी थीम अलग होती है. तो किसी भी स्टेट का एग्जाम देने से पहले यू नीड टू अंडरस्टैंड कि उसका क्या थीम है, उसका क्या पैटर्न है. ठीक है, तो यहाँ पर सेक्शंस भी याद करने जरूरी हैं व्हेन इफ यू आर गिविंग द छत्तीसगढ़ जुडिशियरी एग्जाम्स. ऑलराइट, अब इजी चीज क्या हो जाती है, सेक्शन 34. तो आप देखोगे जब आपको पता है कि इस बार सेक्शन 34 आया, तो हो सकता है अगली बार सेक्शन 35 आ जाए, सेक्शन 37 आ जाए. तो आपको साथ में ही वो सब रिवाइज करना है. सेक्शन 34 में तो ये है इंक्वायरी बिफोर रजिस्ट्रेशन. सेक्शन 35 इज अबाउट द प्रोसीजर ऑन एडमिशन एंड डिनायल ऑफ एग्जीक्यूशन. सेक्शन 36 प्रोसीजर वेयर अपीयरेंस ऑफ द एग्जीक्वेंट और द विटनेस इज डिजायर्ड. सेक्शन 37 वेयर द ऑफिसर और द कोर्ट टू इशू एंड कॉज सर्विसेज ऑफ समन्स. ठीक है, तो अगली बार और भी कोई सेक्शन आ सकता है, तो इसीलिए सिर्फ वो सेक्शन नहीं पढ़ना, सारे सेक्शंस पढ़ने हैं आगे पीछे के जो भी दिए हुए हैं. तो आप जितनी जल्दी जल्दी रिवाइज करोगे और जितनी बार रिवाइज करोगे उतना आपके लिए अच्छा होगा. और बेस्ट मेथड है रिवाइज करने का जब आप उसको विजुअल लर्निंग के थ्रू और टेस्ट देते हुए सॉल्व करते हो. ठीक है, इसलिए आप सिमुलेटर मॉक टेस्ट भी जरूर दीजिए. ऑल राइट, सी आई वॉज टॉकिंग अबाउट द रिटेंशन रेट. अल्टीमेटली हमारे जो भी पढ़ने का और जो भी टेस्ट देने का हर चीज का जो मोटिव है वो है रिटेंशन रेट. रिटेंशन रेट क्यों इतना इंपॉर्टेंट है? क्योंकि एग्जाम में जब आप जाओगे यू वॉन्ट बी हैविंग एनी बुक्स, तो आप कैसे एग्जाम में आंसर्स आपने लिख पाओगे? ओनली थ्रू रिकॉलिंग. रिकॉलिंग कैसे बेटर होगी? जब आपका रिटेंशन अच्छा होगा, आपने जो पढ़ा आपके दिमाग में कितनी देर तक है ये जानना जरूरी है. ठीक है, तो सी देयर वाज अ स्टडी व्हिच वाज कंडक्टेड व्हिच सेड जब वर्बल ओनली रिप्रेजेंटेशन होती है तो 3 आवर्स का उसका रिटेंशन रेट 25% होता है, बट 3 डेज के बाद उसका रिटेंशन रेट सिर्फ 10% पड़ता है. तो वॉच आउट ऑल दोज पीपल जो भी सिर्फ वीडियोस देख के पढ़ रहे होते हैं. आपको इन थोड़ी देर के लिए 25% चीजें याद भी रहेंगी, बट अल्टीमेटली एग्जाम में 10% चीजें 3 दिन बाद आपका 10% हो जाएगा. एग्जाम तो पता नहीं कब होगा, सो अल्टीमेटली आपको कुछ भी नहीं याद रहेगा. ठीक है, फिर दूसरी है जस्ट रिटन टेक्स्ट. अब वो लोग ध्यान दें जो सिर्फ बुक्स से पढ़ते हैं. रिटेंशन रेट्स 3 आवर्स का अच्छा है 70%, बट आफ्टर 3 days you tend to forget many of the things and the retention rate is just 10%. And further, now अब जो टेक्स्ट और विजुअल्स दोनों देखते हैं, वेरी स्मार्ट पीपल यू आर. ओके, योर रिटेंशन रेट आफ्टर 3 आवर्स इज 80%, बट आफ्टर 3 days इट रिड्यूस्ड टू 60%. सिग्निफिकेंट रिड्यूस हुआ है ना, पर 60% आपको फिर भी याद है. यू हैव मेड द स्मार्ट चॉइस. ऑल राइट, अब तीसरी बात, if you are with Edzorb, not only the text but the visuals with the test which is all provided in our premium 3.0, and with 3 hour का retention is 90% and 3 days का retention is 70%. तो जो Edzorb के साथ है, of course they have the 10% extra privilege, और 10% तो बस केस ही उल्टा सुल्टा कर देता है, या तो इधर होता है या उधर होता है. So study smartly and choose wisely. Okay, you know your best, you are the best judge of yourself कि आपके इंटरेस्ट के लिए क्या चीज अच्छी है. All right. So now the next question number 64. When the office of registrar of a district is temporarily vacant, who has power to appoint the person to act as a registrar till the vacancy is filled? Governor on the advice of state government, Inspector General of the registration, or the district judge? The correct answer is C, Inspector General of the registration. And this was from the module 1 of the Edzorb law Q bank, and it is provided in the section 10. Absence of the registrar on vacancy of the office. When any registrar other than the registrar of a district is absent, or when the office is temporarily vacant, any person to whom the Inspector General appoints on his behalf or in default of such appointment. अब अगर Inspector General ने appoint नहीं करा है तब क्या होगा? The judge of the district court shall be the registrar during such absence. ठीक है, सिंपल सी बात है. रजिस्ट्रार एब्सेंट है तो कौन अपॉइंट करेगा? द इंस्पेक्टर जनरल ऑफ द रजिस्ट्रार. अगर उन्होंने ऐसा कोई अपॉइंटमेंट नहीं करा है तब कौन रजिस्ट्रार होगा? द डिस्ट्रिक्ट जज. ऑलराइट, मूविंग फर्दर, क्वेश्चन नंबर 65. Which one of the following documents may be presented and deposited at any time? Gift of immovable property, power of attorney, will, or sale of immovable property? The correct answer is will. Very important question. It may be asked again. Module 2. This is from the module 2 of the Edzorb law Q bank. Okay, this is provided under section 27. इस बार पूछ लिया कि कौन सा डॉक्यूमेंट है, अगली बार पूछ लेंगे कि कौन सा सेक्शन है. तो साइमल्टेनियसली दिस नीड्स टू बी प्रिपेयर्ड. ऐसा नहीं होगा कि एक बार आप सिर्फ कंटेंट पढ़ो सेक्शन का, एक बार आप सिर्फ सेक्शन पढ़ो, सब कुछ साथ साथ में पढ़ना पड़ेगा, ठीक है। तो सेक्शन 27 में प्रोवाइडेड है कि विल को हम किसी भी टाइम रजिस्ट्रेशन के लिए प्रेजेंट कर सकते हैं। In this picture it is provided, this old man is saying, could you please deposit my will? I had made it long ago. उनको डर है कि कहीं ये कोई प्रोसीजर में लफड़ा ना हो जाए, but he says, okay, I know it can be deposited anytime, so you need not to worry. अब आपने ये शॉर्ट स्टोरी पढ़ ली तो एक ये विल वाली चीज आपको याद रहेगी कि ये किसी भी टाइम प्रेजेंट कर सकते हैं, ठीक है। All right. And also section 18 provides that registration of the will is optional. It is not at all required for it to be registered. Okay, so now the next question we have is, provision relating to enforcing the appearance of the executants and witnesses have been provided in which part of the Registration Act? Part 6, 7, 8 or 5? The correct answer is part 7. That is question number answer B. And it was from the module 2 of the MCQ factory. Now the next question. The condonation of delay is not making complaint within the time is provided under which section? It is provided 147, 142, 141 or 140. It is provided under section 142. And this was from the simplified notes of the Negotiable Instrument Acts. Okay, section 142 is provided here. And here it is written the complaint should be made within one month of the date on which the cause of action arises. Alright, now moving further. Question number 68. Under section 31 of the Negotiable Instrument Acts, the liability of the drawee shall be towards the drawer, holder in due course or payee. The correct answer is drawer. And this was again from the module 5 of the Edzorb Law Q Bank. Section 31 provides it for it wrongful dishonor of the check. मतलब आपके बैंक में पैसे थे पर फिर भी बैंक वालों ने उसको dishonor कर दिया, तो अब क्या होगा? It is the duty of bank to honor the check when there are sufficient funds. तो ये उसकी ड्यूटी है, बट फेलियर टू परफॉर्म सच ड्यूटी दे आर लायबल टू पे द डैमेजेस टू द ड्रॉअर ड्यू टू द डिफॉल्ट. ऑलराइट, अगेन दिस पिक्चर इज प्रोवाइडेड टू यू. He is the drawer. He is saying, hey bank, you dishonored the check due to the insufficient fund. Can you see I have more money than to be encashed? Then what bank is saying? Sorry sir, we'll pay you for the losses. So bank is liable to compensate loss to the drawer, which is provided in which section? Section number 31. All right. Question number 69. Provisions relating to endorsement for part of sum due is provided under which section? 53, 54, 55 or 56? The correct answer is D. It is provided under section 56. And this was from the simplified notes of the Edzorb Law Premium. Section 56 देखते हैं. It is for the endorsement for the part of the sum due. Alright. Moving on to the question number 70. A promissory note, bill of exchange or check payable by order is negotiable by the holder by endorsement, delivery, endorsement and delivery, endorsement or delivery. Okay, here it provided and or. The correct answer is C. See कितने minor difference से options दिए हुए होते हैं. ये वही कर सकता है जिसने बहुत सारे questions attempt करे हो, बहुत सारी MCQ की practice करी हो. इस तरह के questions वही attempt कर सकता है. और Edzorb provides you more than 10,000 of the MCQ questions for the practice, and that too not the repeated ones. Only those are repeated which are very important. Otherwise the questions are not repeated. तो 10,000 जब आप more than 10,000 quality questions जब आप attempt करते हो तो उससे बाहर तो कुछ नहीं आता है. All right, and this was again from the simplified notes. Now the next question. The holder's right to duplicate of the lost bill is provided in which section? It is provided in section 45A. Okay, and this was from the simplified notes of the Edzorb Law Premium. 45A provides for it the holder's right to duplicate of the lost bill. It provides where bill of exchange has been lost before it's overdue, the holder may apply to the drawer to give another bill to the same tenor. ठीक है. Further, giving security to the drawer to indemnify him against all the persons in case the bill is alleged to be lost is found again. अगर आपको कोई loss होता है, then he will be indemnified. And further, the drawer may be compelled to do so if he refuses to give duplicate bill. तो ये drawer can be compelled to give such bill. All right. Now, which of the following presumption is prescribed under section 118 of the Negotiable Instruments Act? Of consideration, as to date, as to the time of acceptance, or all of the above? The correct answer is D. And this was from the module 2 of the Edzorb Law Q Bank. See, section 118, very important section of the Negotiable Instruments Act. कौन से presumption से provide करता है? Of consideration, that every negotiable instrument was made or drawn for the consideration. ठीक है. As to the date, कि जो भी date होगी, it is presumed that it is made or drawn on such date. As to the time of acceptance, he within a reasonable time before its maturity was accepted. As to the time of transfer, every transfer of negotiable instrument was made before its maturity. As to the order of endorsements, जिस order में वो appear होते हैं वही माने जाएंगे. holder in due course. Whoever is the holder of a negotiable instrument, he would be deemed as the holder in due course. All right. Now the next question. The fee payable under Court Fee Act 1870 shall be computed according to the amount claimed in the money suits, on the full value of the plaintiff's share in the property in suits for the partition, on the half value of the subject matter of the suit in maintenance suit, or none of the above. The correct answer is A. Okay, and this was from the simulator mock 1. Section 7 provides for it, computation of fees payable in certain suits. Okay, very important section, frequently asked one also. Question number 74. In suits for interim profit or for immovable property and for interim profit or for account, if the profit or amount decreed exceeds the profit claimed or the amount on which the plaintiff has assessed the relief sought, then the decree will be executed. It is at the discretion of the court whether to execute or not. The execution court cannot examine the valuation or none of the above. The correct answer is none of the above. And this was from the Court Fees Act, Module 4 of the MCQ Factory 3.0. Now question number 75, where the amount of interim profit is left to be determined during the execution of the decree, there, if the profit so ascertains exceeds the claimed profits, then what happens? The execution of the decree shall be stopped. Second option is given. The decree shall be executed unless the difference between the fee actually paid and the fee which would have been payable if the whole of the profit identified was included in the suit. If the additional fees is not paid within such time as the court shall rule, the suit shall be dismissed. So which are the correct statements? 1. All statements are correct. All right. Now the question number 76. Among the following statements, the true statement is, अब इसमें से हमें बतानी है true statement. Let's see the statements. The net profits or the market value has been estimated. The court shall require the amount to be paid as insufficient, and if it is not paid within the stipulated time, dismiss the suit. The question of valuation on a plaint or memorandum of appeal is determined by the court where the suit is pending and its decision is final. The court in which the plaint or appeal is filed and the assessment made by that court is insufficient, the reference shall require the Court of Appeal or Revision to pay the additional fee, and if it is not payable within the stipulated time, dismiss. And the option is all of the above. The correct answer is D. Okay, so now we have question number 77. Among the following statements, the true statement is, if the application for review is partly or wholly due to the new evidence being modified or reversed, the court shall authorize the application to recover the fee paid. Secondly, where the court on the application for review reverses its absolute decision on the ground of lapse of law or fact, shall authorize the refund of such fee by the amount exceeding the amount when the other application has been made, or both can be. The correct answer is B here. Now the next question, number 78. Which provision of the Limitation Act specified that where the letter of administration of the estate of a creditor has been granted to his debtor, the continuance of the limitation of the suit to recover such debt shall be suspended? It is provided under which provision? It is provided under Section 9 of the Limitation Act. Now it is from the simplified notes of the Limitation Act, Edzorb Law Premium 2.0. Okay, Section 9 talks about the continuance running of time. It says that once the time has begun to run, then no subsequent disability or inability to institute a suit or make an application stops it. So इससे पहले जो sections हैं वो कहते हैं कि अगर आपकी कोई disability है या inability to file the suit है, you are being the minor or you are being incapable, in that case आपको उतना आगे time provide कर दिया जाएगा. For like limitation won't start run until that time unless you become the capable. But once you become capable, even for a day, and the next day you become incapable, like you may fall sick or whatever, for whatever reasons, then the time won't stop. It will continue to run unless the whole of the limitation expires. All right. See, time ऐसे ही चलता रहता है. You need to take control of the things in your hands. These days, the coaching institutes, they are like taking 2 to 3 years to just complete the course. आप 3 साल में course complete करोगे या 2 साल में, उसके बाद आप 1-2 साल self study करके तैयारी करोगे, ठीक है? उसके बाद आप exams दोगे, फिर कहोगे चलो एक attempt और दे देते हैं. 5-7 साल आपके कहाँ चले जाएंगे, you won't even be knowing. So take control of the things in your hands. आप अपना इकोसिस्टम इस तरह से बनाइए, मीन्स आंसर राइटिंग प्रैक्टिस करिए, प्रीलिम्स के आंसर्स करिए, एक्सप्लेनेशंस पढ़िए, मीन्स एग्जॉस्टिव तैयारी आप करेंगे. दैट इज हाउ यू कैन टेक कंट्रोल ऑफ द थिंग्स इन योर हैंड. ऑलराइट. और जब आप इस तरह से तैयारी करते हो तो आप डेफिनेटली बहुत ही जल्दी अपने गोल तक पहुंच जाते हो. ऑलराइट. सी, आप सेक्शन 9 में ये पूरा इसके आपको प्रोवाइजोस आर प्रोवाइडेड टू यू. The leading case related to that. All right. Now we have question number 79. Select the correct option by match the following under the Court Fees Act. Column A and column B are provided to you, and here are the options. Schedule 1 from related to fixed fee schedule. Schedule 2 advanced fees. Schedule 3 format of assessment. The correct answer is option number C. Okay. Now we have question number 80. Where at the time of making an application for probate of a will or for a letter of administration, any person who has estimated the property of the deceased to be overvalued and has paid a very high fee, the probate before the Chief Controlling Revenue Authority within the determination of the true value of the property or present a letter of administration. ठीक है, क्या होगा इसका आंसर? It is A. All right. And this was from the module 6 of MCQ Factory of the Edzorb law. Okay, now moving further with question number 81. Once the calculation of the limit is started, it will continue to run again and again. The exceptions to this rule are time taken to receive copy of decree or order for appeal or review, debtor's letter of administration, time in the case of akinchan. Who is akinchan? Akinchan means pauper. If in good faith, any other civil proceedings in a court without jurisdiction, when an injunction has been obtained to prevent the filing of the suit, the correct option is A. All the options are correct here. अब see ये prelims का question तो है, पर ये same to same mains में भी आता है. आता है कि once the time has begun to run, this is the general rule and what are the exceptions to this. So you need to explain each of these. अब आप जब ये question attempt करते हो इस तरह से, तो आपको इसका explanation पढ़ना बहुत ज़्यादा ज़रूरी है, ताकि ये एक question limitation का जो कि hot favorite topic है for the mains examiners, तो आपका ये साथ में prepare हो जाना चाहिए. ठीक है, देखते हैं कि कैसे. लेट्स सी द सिंप्लीफाइड नोट्स ऑफ सेक्शन 9, 12, 13, 14 एंड 15 ऑफ द लिमिटेशन एक्ट. पहली चीज जनरल रूल हमने डिस्कस कर दिया, सेक्शन 9 कॉन्टिन्यूअस रनिंग ऑफ टाइम कि ये हमने एक्सप्लेन कर दिया इसको पूरा. देयर आफ्टर उसके जो एक्सेप्शंस हैं, लेटर ऑफ एडमिनिस्ट्रेशन एंड सेकेंडली सूट टू रिकवर अ डेट, ऑप्शंस में अभी प्रोवाइडेड था. फर्दर Section 12 talks about the exclusion of time in the legal proceedings. In case of suit, appeal or application, the day from which the limitation period is to be computed is excluded. In appeal, application for appeal or revision or review of the judgment, the day from which the judgment complaint was pronounced and the time required for obtaining the copy of decree, sentence or order. Thirdly, the decree or order is appealed or application, the time requisite for obtaining the copy of judgment shall be excluded. All right, application to set aside an award, the time required to obtain an award. That is it. Now section 13, exclusion of the time in cases where the leave to sue as pauper is applied for. Very important section. This section independently can come as a mains question or as a prelims question also. All right, or collectively तो ये question आता ही है. ठीक है. If any person prosecuted in good faith, all right, as a pauper, फिर वो leave to sue or appeal as pauper is rejected, then on the payment of fees of the prescribed fee, it shall have the same force or effect if as he has paid the fees at the very first instance. तो जितने time वो in good faith application लगा रखी थी उन्होंने for the suit or for the appeal, that time would be excluded. All right. Now see this picture. This pauper is saying I filed suit as pauper on this date, 22nd of February 2019. अब वो एप्लीकेशन डिसाइड होते होते 2020 आ गया. अब कोई कहे कि आपका तो लिमिटेशन पीरियड खत्म हो गया, नहीं. द सूट विल बी डीम्ड टू बी इंस्टीट्यूटेड ऑन दिस डेट ओनली. ओके. नाउ फर्दर वी हैव सेक्शन नंबर 14. The time during which the plaintiff has been prosecuting in another civil proceedings, whether in a court of first instance, appeal or revision against the defendant shall be excluded. तो क्या requirements है section 14 की? Previous suit prosecuted with due diligence, matter in issue is both in the same suits, didn't entertain the suit due to the defect in the jurisdiction, other cause of like nature, or previous suit prosecuted in a good faith. Now subclause 2 is provided to you, subclause 3 is provided here. Now section 15 is provided to you. ये पूरा एक आंसर है मेंस का. देखो आपने प्रीलिम्स के लिए पढ़ा, आपने मेंस का साथ में ही पढ़ लिया. यही अप्रोच ही रखनी है आपको, प्रीलिम्स कम मेंस इंटीग्रेटेड अप्रोच. आपको दोनों की तैयारी साथ में ही करनी है, एक होलसम तैयारी होनी चाहिए ना. सेक्शन 15 में क्या पीरियड्स एक्सक्लूडेड है? द टाइम ऑफ कंटिन्यूएंस ऑफ इंजंक्शन और ऑर्डर, डे ऑन विच इट वाज इशूड, डे ऑफ इट्स विड्रॉल, ये सब क्या है इसके? एक्सक्लूजन ऑफ द टाइम पीरियड. ऑल राइट, नाउ वी हैव नेक्स्ट क्वेश्चन. The important case of the Supreme Court, the land acquisition officer Anantnag versus Katiji, is related to Section 6, Section 5, Section 7 or Section 9. It is related to Section 5 of the Limitation Act. And this was from the CGS Simulator Mock 2. You can see this flashcard also. This is related to expression related to sufficient cause provided in the Section 5 of the Limitation Act. Okay, moving further. The important case of the Supreme Court, W.N. Balakrishnan versus M. Krishnamurthy, is related to the length of delay is no matter, acceptability of the explanation is the only criterion, the condonation of the delay is a matter of discretion of the court, widen the scope and ambit of the law of limitation. The correct answer is all of the above. And this was again from the flashcard series of the limitation high yield. See, आपको पता है क्या फीडबैक आ रहा था आफ्टर दिस एग्जामिनेशन कि पता नहीं कहाँ से केस लॉस आ गए थे, इतने सारे मतलब नॉट सो सेलिब्रेटेड केस वर देयर, लिमिटेशन एक्ट्स के इतने केस लॉस पूछे थे, बट जो एड्जॉर्ब के प्रीमियम यूजर्स थे दे न्यू द फ्लैश कार्ड्स, और ये सी फ्लैश कार्ड्स वर प्रोवाइडेड टू देम एंड ऑल दीज केसेस वर देयर. तो इतना एक्सटेंसिवली वी हैव कवर्ड एवरीथिंग इन आवर कंटेंट. नेक्स्ट देखते हैं. Now again this another question is from the case laws only. In a case the Supreme Court held that the Indian Limitation Act 1963 is only general law for the whole country. All the other laws determining the period of limitation are either special laws or local laws. If they fix time period for the specific cases, they will be called special laws. The correct answer here is Justiniano versus Antonio. And this was again from the CGS Simulator Mock. See, Chhattisgarh के mock में ही आया था. This is telling you the importance of the mock test. These are provided free to you, free to all of you. You must attempt these. इसमें से बहुत questions आते हैं क्योंकि ये previous years upcoming उसकी जो भी theme चल रही होती है उस हिसाब से scientifically आपके लिए design किए जाते हैं. Alright, see again the flash card is provided to you. अब ये case वही कर पाएगा जिसने पढ़ा होगा Edzorb के साथ. Okay, now the next question. In order to acquire the right to easement against the government property, by virtue of which it is prescribed a period of 30 years, 60 years, 20 years, and 25 years. The correct answer is period of 30 years. This is again from our mock test. And this is section 25, which provides for it. That where the property belongs to the government, 20 years to be substituted with 30 years. Okay. Now the next. An application for review of the decision of the court should be made within 30 days from the date of order or a decree. Supreme Court, High Court, in the Supreme Court or the High Court or none of the above. C. The correct answer according to us is A, but the official answer key में the correct option was B. Okay, this was from the simplified notes of the section 114 of the Civil Procedure Code. Section 114 provides for the review. Okay. The whole section is provided to you right below the question. All right. This is the leading case in this regard. Okay. Now the next question. A owes rupees 1 lakh to B. B is entitled to recover this amount from A. This is called rights in personam, rights in rem, constitutional right. There is no right at all. The correct answer is right in personam. And this was from the module 3 of MCQ Factory of Edzorb Law. Now the next question. A has bought a house for 50,000. Which of the following rights is available to A after the purchase? He has a right against the seller to have quiet possession of the house and enjoy in it. He has a right against the whole world to have a quiet possession of the house and enjoy in it. He has a moral right over the house. He has right to live in the house, but he cannot sell. The correct answer is option number B. And this was from the module 4 of the MCQ Factory Edzorb Law Premium. Alright, so now we have question number 89. A and B enter into a contract to marry each other. Before the time fixed for the marriage, A goes mad. A contract becomes void, illegal, valid, or voidable. The correct answer is void. And this was from the simplified notes of the Indian Contract Act. Now let's see the section 56. Section 56 is about the agreement to do the impossible acts. कोई चीज impossible है उससे related अगर कोई आप agreement करते हो, that would be void. So if two parties enter a contract where the promisor agrees to do an impossible or unlawful act, then the contract is void. When contract becomes impossible or unlawful. As Ria is not here, now see this picture, as Ria is not here at present, let me make this picture quick to discover the treasure. So this agreement of finding the treasure is void. There is no treasure. Treasure lies only with Edzorb. Okay, so go hunt it. Now section 90. Where a particular type of contract is required by law to be in writing and registered, it must comply with necessary formalities as to writing registrations and attestations. Otherwise, such contract is void, illegal, valid, or unenforceable contract? The correct answer is unenforceable contract. This was from the simplified notes of the section 10. Section 10 talks of all agreements are contract. Like all agreements are contract if they are made, again the same. अभी हमने explanation ऊपर पढ़ा था, सी उसी explanations में से ये question दोबारा से आया हुआ है. Okay. Now the next question, question number 91. A contract in which, under the terms of the contract, one or both the parties have still to perform their obligation in future is known as executed contract, executory contract, unilateral contract, or none of the above. The correct answer is executory contract. This was from the simplified notes of the Indian Contract Act. See, now this beautiful flowchart is provided to you. The types of contracts on the basis of validity and enforceability, formation, and performance. See, validity or enforceability के basis पे there are valid contracts, voidable, illegal, and enforceable, unenforceable contracts. Formation के basis पे there are express contracts, implied contracts, quasi contracts, and e-com contracts. Performance के basis पे there are executed contracts and executory contracts. And further, executory contracts is divided into two parts: unilateral contracts and bilateral contracts. Okay, now the next question, question number 92. All government contracts made in exercise of the executive power of the Union shall be expressed to be made by the President under which article? It is provided under Article 299 of the Constitution. And this was from the Module 14 of the Edzorb Law Bank. See, फिर से ये section based question था, section article number पूछा गया आपसे, तो these are more some more articles जो कि आपसे पूछे जा सकते हैं, जैसे कि article 279 calculation of the net proceeds, article 280 relates to the finance commission, very important article, this is frequently asked. Article 293 is about the borrowings from the India, article 299 is about the contracts. Okay. Now we have question number 93. If the agreements consist of the legal and illegal parts, and the legal part is separable from the illegal part, then legal part is none, voidable, void, or valid. It is valid. Okay. It is from the module 15 of the MCQ factory. Now the next question. In which of the following cases J. Kikiewicz observed that you cannot limit an estate to a man and his heirs until he shall convey the land to the stranger, because it is of the essence of an estate in a fee that it confers free power of alienation, and it has long been settled that the game principle is applicable to gifts of personality. It was held in which case? Metcalfe versus Metcalfe, Dio versus Bevan, Tamaya versus Timpa, and Hippolyte versus Stuart. The correct answer is Metcalfe versus Metcalfe. Now the next question, the Privy Council in Muhammad Sher Khan versus Seth Swami Dayal has settled that Section 98 of the Transfer of Property Act is subject to the Section 60 of TPA. Section 60 of TPA is subject to Section 98 of TPA, either A and B depending upon the facts of the individual cases, neither A nor B. The correct answer is A here. And it was again from our mock test. Again, I'm emphasizing upon the quality and the importance of these mock tests. Rest you decide for yourself. Again, this flashcard is provided to you. And I must tell you, do join our Telegram channel. It's Edzorb Law Official. That would be the best channel that you're joining, and that would be the best decision. There's a lot of free content provided to you. Like I said, Chhattisgarh local laws are provided to you. And apart from that, this document also is provided to you in that channel. Okay. Now, next question. Section 37 of Transfer of Property Act refers to apportionment by estate. In this slide, before the TPA 1882, when a transfer was severed by the sale of shares in the version of tenant was still obliged to pay the rent to all shares jointly, unless an apportionment had been agreed to by all the parties. Any parties is agreed by all the parties. Two parties are agreed, or none of the above. The correct answer is A here. This is from the simplified notes of the section 37. Now the section 37 provides for it that when on a transfer of property is divided between several persons by proportion, then each transferee is entitled to the advantages accruing to a property. ठीक है, एक प्रॉपर्टी है जो कि काफी लोगों में डिवाइडेड है, तो उससे जो बेनिफिट आएगा वो भी सब लोगों में डिवाइड होगा. But this rule is subject to certain conditions. The person on whom the burden of obligation lies must have the notice of severance. All right, obligation must be severable. Severance should not increase the burden of the obligation. Person with the corresponding duty must perform the duty to several owners. अब नोटिस ऑफ सेवरेंस कैसे देना है, ऑलराइट, और उसके क्या वो होंगे, दैट इज प्रोवाइडेड टू यू. ओके, leading case law regarding that. Okay, now let me show you one more example that how evaluation is done at Edzorb. So this is the case this is the question from the constitution, and one of the students have done it. Now see, कितने बारीकी से आपको इवेल्युएशन मिलता है. आई डोंट थिंक कि कहीं पर भी आपको इतना ज्यादा फीडबैक मिलता है. सिर्फ नॉर्मली नंबर्स देके आपको छुट्टी कर दी जाती है. आप कोई से भी मेंस टेस्ट सीरीज आप ज्वाइन करो, सिर्फ आपको नंबर दे देते हैं. उससे क्या होता है कि आपको पता ही नहीं चलता आप गलती कहाँ पर कर रहे हो. जब तक आपको आपकी गलती नहीं पता चलेगी, हाउ विल यू इम्प्रूव दैट. ठीक है, नाउ लेट्स टेक दिस एग्जाम्पल दैट हाउ इट इज डन. अब यहाँ लिखा है नॉट कंपेल टू अ विटनेस. वी मस्ट इंक्लूड व्हाट डज द कंपेल मीन. ओके, आप सिर्फ केस का नाम मेंशन कर दिया. वी हैव नॉट मेंशन एनी फैक्ट्स और इशू. एटलीस्ट 1 और 2 लाइंस में वी नीड टू मेंशन दैट आल्सो. ओके, एंड फर्दर कुछ भी नहीं लिखा कि नार्को एनालिसिस और अदर टेस्ट ये होते क्या हैं. कुछ एक छोटा सा ब्रीफ इन अ लाइन, इट मस्ट बी देयर. ऑलराइट, एंड फर्दर सेक्शन आर्टिकल 20 और 300 के बीच के कंपैरिजन भी नहीं लिखा हुआ कि उनका डिफरेंस क्या है और उसमें क्या सिमिलैरिटी क्या है. ऑलराइट, the spelling mistakes are there. See, you need to pinpoint the difference between this. So after this feedback, of course this student will incorporate these things in her answers, and it will definitely give them an edge over others. Now see, यहाँ लिखा है no person shall be arrested. अब arrested नहीं आएगा, no person shall be convicted है. तो एक एक वर्ड का इंपॉर्टेंस है. अभी being a law student you must know it. ठीक है, एक कॉमा, एक सेमीकोलन, एक फुल स्टॉप, everything has an importance. Okay, now a case is not discussed. What if the punishment is reduced? अब इसमें लास्ट में सिर्फ लिखा है the offence has the same meaning as defined in section 26 of the General Clauses Act. मतलब आप एग्जामिनर को बोल रहे हो कि General Clauses Act का section 26 जाके देख लो. So this is not self-explanatory, right? So we must provide and at the end we must provide a well-rounded conclusion. Now we have next question. Section 5 of Transfer of Property Act applies to the property sold in auction sale. Does not apply to a property sold in auction sale. Applies doubtfully. Applies to the doubtful rights to compromise or doubtful rights. Does not apply to compromise of the doubtful rights. The correct answer is B. This is from the simplified notes of the Transfer of Property Act. Section 5 क्या कहता है? It talks about the transfer of property, an act by which a living person conveys a property in present or in future. आज कन्वे कर रहा है या फ्यूचर में कन्वे कर रहा है किसको? टू वन और मोर अदर लिविंग पर्सन्स. ऑलराइट, और टू हिमसेल्फ. अपने आप को भी हम प्रॉपर्टी ट्रांसफर कर सकते हैं. इन वन और मोर अदर लिविंग पर्सन्स. टू ट्रांसफर सच प्रॉपर्टी इज टू परफॉर्म सच एक्ट. एंड फर्दर लिविंग पर्सन्स इंक्लूड्स company, association or body of individuals, whether incorporated or not. All right, now the next question. In which of the following cases the rule against the perpetuity is not applicable under the Transfer of the Property Act 1882? In case the property is transferred for the benefit of lineal descendants, in case the property is transferred for the purpose of construction of winery, in case the property is transferred for the purpose of creating a temple promoting sati, in case the property is transferred for building the library of the comic book. The correct answer is D. This is from the simplified notes of the TPA section 14. Section 14 is about the rule against the perpetuity, that no transfer of property can operate to create an interest if it is to take effect after the lifetime of one or two living persons living at the time of transfer, and the minority of some person who shall be in existence at the expiration of that period. Okay. Now the next question, and before proceeding that, I must tell you that Edzorb also provides to you the judgment writing power pack course. Judgment writing either breaks your mains examinations or it can break you. ज्यादातर आप जो भी टॉपर्स देखोगे उनके ज्यादा मार्क्स जजमेंट राइटिंग के एग्जाम में ही आते हैं, क्योंकि लॉ के पेपर में मोर और लेस एवरीबडी गेट्स द सेम मार्क्स, बट जजमेंट राइटिंग का पेपर है दैट गिव्स यू एन एज. एंड व्हाट Edzorb provides you, it provides you the notes, practical workbook and test series, sample judgments, and also the creative judgments. Okay, now the next question number 99. B transfers some property to C with the condition that in case A marries during B's lifetime, the property will go to A. A marries during B's life. Which of the following statements will apply? The transfer to C is void and property reverts back to B. The transfer and conditions are valid and the property will transfer to A. The transfer is valid but the condition is invalid. Property remains with C. The transfer is voidable at C's option. The correct answer is B here. And it is from the simplified notes of the section number 25. Now section 25 relates to the conditional transfers. क्या होते हैं conditional transfer? Where the transfer of property होती है when an interest created fails as it is dependent on a condition. जब वो condition fulfill नहीं हुई तो then that transfer would also fail. और अगर वो condition fulfill हो जाती है तो transfer will take effect. तो इसको बोलेंगे हम conditional transfer. But if the performance is impossible, forbidden by law, or defeat the provision of law, it is fraudulent or involves the injury to a person or public property or is immoral or opposed to public policy, तो वो condition मानी ही नहीं जाएगी. Okay. Now the last question of the session, question number 100. According to the provision of the Transfer of Property Act, the easements can be transferred, cannot be transferred apart from the dominant heritage, can be transferred apart from the dominant heritage. The correct answer is C here. And it is from the simplified notes of the TPA of section 6. Section 6 talks of what may be transferred. Very important section. It can come into your mains exams also. तो सेक्शन 6 क्या कहता है? जनरल रूल पहले प्रोवाइड करता है कि प्रॉपर्टी ऑफ एनी काइंड मे बी ट्रांसफर्ड, पर उसके कुछ एक्सेप्शंस हैं. क्या एक्सेप्शंस हैं? फर्स्ट है स्पेस सक्सेशन. अगेन द वेरी इटसेल्फ अ क्वेश्चन इन इटसेल्फ, पूरा फुल मार्क्स का क्वेश्चन इस टॉपिक पे बनता है. व्हाट इज स्पेस सक्सेशन इज. ओके. And further, a mere right of re-entry for the breach of condition subsequent except the owner of the property is affected. Unless the owner of the property is affected, आप किसी का re-entry का breach right जो है वो transfer नहीं कर सकते. And there are many more other things like an easement, restricted interest, a right for future maintenance, a right to sue, public office and salary, pensions and stipends to the military, naval, air force and political pensions. Okay. And no transfers can be made where they're opposed to the nature of interest, unlawful object or considerations are there, legally disqualified to the transferee. All right. So as we wrap up this session, just remember that the only place where the success comes before the work is dictionary. So unless you work hard, you won't be achieving any success. तो ये जो आपकी dedication है for the consistent learning, that acts as a bridge between your dreams and your achievement. So consistent learning is the key. So until we meet again, keep learning, be consistent, believe in yourself and keep working hard, keep shining and keep your ambitions high. Take care. Bye-bye.